Having a family law case can be a nightmare. You're emotionally stressed out, worried about your kids, how much it will cost, and what your wife, husband, or partner is going to do next. You don't think you can afford a lawyer, but you don't know how the legal process works. The only thing you know is that you need help and you want it to be as fast and as simple as possible. We hope that this video will give you an overview of the family law process. This video was made in October 2001, so remember, there may be subsequent changes in law and procedure. Remember, too, that the court system is passive. The court can't do anything unless you ask. The way to ask for help is for you to prepare, file, and serve a motion. We'd like you to meet an imaginary couple who will be dealing with problems commonly seen in family law court. Bill and Wendy have been married for 8 years. They have 2 children, a house, 2 pensions and a car, and a few $1,000s in credit card debt. This couple wants to get a divorce. Along the way, they need to deal with child support and child custody issues. This video will be divided into 3 parts: how to start your divorce, how to file motions in court for support and custody, and how to collect and enforce support. The process starts at the courthouse at 725 Court Street in downtown Martinez. Parking is very scarce, so always leave plenty of time to find a parking space. Bill and Wendy have decided that they want to file for divorce. Bill goes to the courthouse to begin the process. Security is very tight at the courthouse. You will go through a security check at the door. No weapons are allowed. This includes pocket knives. The first stop is the clerk's office in room 108. Here, he gets his forms. He's told that there are free workshops on how to complete his divorce taught by local attorneys, and that the family law facilitator can assist him in requesting child and spousal support. He's also told that the Department of Child Support Services, DCSS, can bring an action requesting child support on behalf of his children and can collect on any child support order made on their behalf. We will talk more about the family law facilitator and the DCSS later on in this video. There are also websites where you can receive information about family law matters. The website for the Contra Costa Superior Court is www.cc-courts.org. The website for the California Courts Self-Help Center is www.courtinfo.ca.gov. And the website for the Contra Costa County Bar Association is www.cccba.org. The clerk gives Bill the forms that he will need to start his divorce case. On average, a forms package will cost $5. Bill decides to attend the How to Start Your Dissolution workshop run by the Bar Association. In the workshop, Bill learns how to complete the forms he needs to start his divorce, and he will be able to complete these documents during the workshop. After the workshop, Bill takes his completed forms across the street to the law library where the copy machines are, and he makes at least 3 copies of each form, 1 for himself, 1 to serve on Wendy, and an extra copy. Then he files his papers at the courthouse. The fee to file his initial papers is about $200. However, the filing fees increase periodically, so it is a good idea to contact the clerk's office prior to coming to file your papers to learn what the filing fee will be in your case. If a party is not able to afford these fees, he or she could apply for a fee waiver, but these are available only for very low-income families. Bill is the petitioner because he filed the first paper. Wendy is the respondent since she received the first paper. Bill will always be the petitioner and Wendy will always be the respondent, even if Wendy later files a motion. Now Bill is ready to have his pleadings and blank response papers served on Wendy. This is the area where many pro per litigants make mistakes. The court does not have the legal power to hear your case until the other side has been properly served. Service of process is the delivery of the filed papers to the other party. Bill can hire a process server for a fee, or we can have a relative or friend serve the papers. The person serving the papers must not be a party to the case. He or she must be over 18. After the respondent has been served, the proof of service form must be completed and filed with the court clerk. The proof of service must specify who was served, when they were served, where they were served, and how service was done. Your process server must sign the proof of service under penalty of perjury. Bill and Wendy should note the automatic restraining orders on the back of the summons. These orders prohibit either party from making any changes regarding property and insurance and prohibit either party from removing any children of the marriage from the state. This means that neither Bill nor Wendy can dispose of property or change the beneficiary on any insurance policy until all of the divorce issues are resolved. These are not domestic violence restraining orders. Please remember, Bill has only filed the initial papers to start the dissolution. There are many other steps that are needed before the court will be able to dissolve the parties' marriage. To repeat an important point, the court system is passive. The court can't do anything unless you ask. The way to ask for help is for you to prepare, file, and serve a motion. Now we are going to talk about filing motions to obtain court orders for child and spousal support and child custody. There is help available for persons who wish to file motions for paternity, for child support, and spousal support. The Office of the Family Law Facilitator was created to help individuals representing themselves on support issues. The facilitator can only help with support issues. The facilitator does not represent either party. The information a party discusses with the facilitator is not confidential. The facilitator can refer customers to community resources. For instance, the County Bar Association runs a lawyer referral service which gives a party a consultation with an attorney for a minimal fee. The facilitator also refers parties to the FLAIR mediation program, which connects parties with attorneys who are trained to act as a neutral third party to assist parties in reaching agreements so that they do not have to go to court. The Family Law section of the Contra Costa County Bar Association sponsors workshops to people without lawyers. Currently, the workshops are held on Thursdays of each month from 1:30 to 4 o'clock p.m. in the Classic Courthouse at 725 Court Street in Martinez. The How to Start Your Dissolution Case workshop is on the third Thursday of the month. The How to Finish Your Dissolution workshop is on the first Thursday of the month. The OSC, How to Request Orders for Custody, Visitation, Child, and Spousal Support workshops are held on the second and fourth Thursdays of each month. The facilitator also frequently refers people who want or need help with the collection of child support to the Contra Costa Department of Child Support Services, DCSS, where they can sign up to have the department establish, modify, and enforce child support on behalf of their minor children. That office is located at 50 Douglas Drive, Martinez. We will talk more about the DCSS later on in the video. Additionally, the facilitator may provide parties with a list of local attorneys, the services they provide, and their fee schedules. The facilitator will also provide the names of attorneys who coach parties through the process. This is called providing unbundled services. The facilitator helps parties to properly fill out their forms and gives information on proper filing and service procedures. The facilitator will describe the court procedures and give information about drafting, submitting, and filing orders after hearing. The facilitator can run the computer program which determines the amount of child support. Unless the parties agree otherwise, child support is determined by a mathematical formula stated in the Family Law Code. The formula is based upon each party's before-tax income, certain limited deductions such as union dues, contributions to mandatory retirement, health insurance premiums, and support paid for other children or spouses. The time each parent spends with the children is an important factor, and if either party has children from another relationship living with him or her, that will be considered. This mathematical formula has been incorporated into a number of computer programs used to calculate support. Child care expenses are also included in the child support, even though this is not part of the formula. Rather, after child support is calculated, child care is usually divided equally between the parents. The computer program also calculates the temporary spousal support which may be ordered at the hearing. There are special rules for obtaining custody and visitation orders in the family court. The first step is to make an appointment with Family Court Services for orientation. Both parties must attend orientation but may do so separately. Orientation teaches parents about the impact of their separation and custody disputes on their children and helps them be more successful in the mediation of their custody disputes. In the emotional stress and strain of a separation, the feelings of the children often get lost. The orientation session helps parents understand some of the steps they have to take to protect their children. Once the orientation is completed, the parents will go through mediation. Mediation with Family Court Services is an opportunity for the parties to meet with a third party to work out a custody share agreement that will be best for their children. Mediation is mandatory. The party who files the motion must call Family Court Services to set up his or her orientation date. When the other party is served, he or she calls Family Court Services to set up a date for orientation. After both parties have contacted Family Court Services, FCS will send a letter to both parties advising them of the date of the mediation session and the date of each party's orientation, unless the parties are meeting separately. In that case, the letter from FCS does not give the relevant dates for the other party. Where domestic violence is alleged in a declaration under penalty of perjury, the party seeking protection may request a mediation session separate from the restrained party. A finding by the court that someone has committed acts of domestic violence can significantly impact the outcome of the ultimate custody orders in the case. Once the motion for custody, visitation, and/or support has been completed and filed, it is served on the other party. Remember, the judge cannot hear your motion unless the other party has been properly served. The party who did not file the motion must file a responsive declaration. The responding party can attend one of the custody and visitation workshops or stop by the family law facilitator's office if he or she needs assistance. Now Bill and Wendy are ready to go to court. Once they arrive at court, there are a number of rules that they must be aware of. First, a judge or commissioner will be assigned to hear their case. If it is a commissioner, the parties will be asked to sign a form authorizing the commissioner to hear the case as a temporary judge. If a party chooses not to sign, the commissioner will make recommended findings and orders which will then be reviewed by a judge. Wendy and Bill will see other people in the courtroom besides the judge. There will be a bailiff who maintains order in the court, a court reporter who takes down the testimony, and a court clerk who records the official minutes for the record. There are a number of do's and don'ts about appearing in court that everyone should know. When you're in court, don't talk when court is in session. Don't wear a hat and don't chew gum. No food or drink is allowed in court. Turn off all cell phones and pagers. Dress appropriately. Don't wear tank tops or shorts. Don't bring children to court. It is very bad for children to see their parents fighting in court, and it's hard for them to be still and quiet. There are certain things that everyone should bring to court. The first and most important are copies of all court papers and files, including all of your financial information, especially a copy of the proof of service showing that the other side was properly served. If the proof of service was not properly filed before the hearing, you must bring it with you to court to show the judge. The judge will not hear your case unless he or she sees a valid proof of service. You should also bring pens and paper with you to court. Now Bill and Wendy are ready to begin the hearing. The judge has already read the pleadings filed by both parties. The parties are sworn and each has an opportunity to speak. The parties should not repeat everything in their declarations. The court will have the results of the mediation session from Family Court Services prior to the hearing. The court encourages the parties to reach agreements about their children, keeping in mind the best interest of the children. If Bill and Wendy are unable to reach an agreement about custody and visitation, the court will review the recommendation from Family Court Services and make orders. After making orders regarding custody and visitation, the judge will make orders regarding the other issues. The judge makes the mathematical support calculations in Bill and Wendy's case and issues child and spousal support orders accordingly. After the court makes its orders, Wendy prepares the order after hearing for the judge's signature. Wendy fills out the form to show the orders that were made and gives it to the bailiff or the clerk. The clerk reviews the order for accuracy before the judge will sign it. Then Wendy files it in the clerk's office, room 103, and has it served by mail on Bill. Child support is often ordered at a hearing. There are several ways to collect child support. The Department of Child Support Services performs many important services at no cost to the custodial parent. They will obtain judgments of paternity for unmarried parties, and they will establish support orders, modify support orders, and collect and enforce support orders. The local DCSS department prepares and serves a wage withholding order on the payer's employer, which directs the employer to withhold the child support payments from the payer's paycheck and send the payment to them. If a party wants to prepare, file, and serve the wage withholding order without the assistance of the DCSS, he or she can still get help from the family law facilitator. If spousal support has been ordered, it too may be collected by wage assignment. If a party who has been ordered to pay child support fails to make the monthly child support payment, he or she would owe back support. This back support is called an arrearage. Under state law, the arrearage is referred to the Franchise Tax Board. The FTB can take 50% of a party's paycheck, or they may empty his or her bank account. If child support is not paid, the Department of Motor Vehicles can suspend the owing party's driver's license. If the party ordered to pay child support is a licensed professional, such as an attorney, doctor, contractor, or dentist, the appropriate licensing agency is also notified, and the agency would suspend the party's professional license for non-payment of support. If the party's license is suspended, he or she could contact the DCSS and try to make an arrangement with the department for a restricted license that would be conditioned upon the party making support payments. If the party is not able to reach an agreement with the DCSS, he or she would have to file a motion with the court to get his or her license back. If the party makes these arrangements with DCSS and then misses a payment after that, his or her license could be suspended again. Automatic withholdings are required by state law, and employers are prohibited from firing or disciplining anyone because of a wage withholding order. There are other important family law issues that are beyond the scope of this video. However, remember that if you have an issue of domestic violence, you need to take action right away. You can obtain help several ways. You can call STAND Against Domestic Violence at 1-888-215-5555, or you can come to room 108 of the courthouse, the Domestic Violence Unit, where you can obtain the forms necessary to obtain restraining orders and other relief. You may also go to the Restraining Order Clinic at the courthouse in Richmond, located at 100 37th Street in Richmond, for help in filing domestic violence papers. You can receive assistance with domestic violence applications in room 185 on Mondays and Fridays from 8 a.m. until 11:30 a.m. You can receive assistance with domestic violence responses in room 175 on Thursdays from 3 o'clock p.m. until 5 o'clock p.m. Another important issue that we did not cover in this video is paternity actions. If you need to obtain custody and support orders and you are not married to the other parent, you need to file a paternity action. The Department of Child Support Services can help you with this, or you can go to the Office of the Family Law Facilitator for assistance. We have now been through the initial stages of what happens in a family law divorce case. Remember, this is only an example of what might happen. Each case is reviewed and determined individually by the court. It is also important to understand that you have seen what happens in the initial stages of the process. Other steps must be taken to finalize your divorce. These other steps are explained in workshops held at the courthouse. As you can see, the more issues that the parties are able to reach agreement on, the more they are able to retain control of their own family situation. Many people are able to work out their divorce issues without ever appearing in court. Some parties also choose to obtain assistance by hiring a mediator to help them work out their issues. Hopefully, you now have a better understanding of how court procedures work and where you can go for assistance with your case. Good luck.